Oh,
yeah,
great. Okay, good afternoon, everyone. We are here to discuss a less sexy but very relevant subject matter, so it won't be about billion-dollar settlements and how they're financed, but class certification, which is still pretty important. And there are different admissibility criteria in different jurisdictions, and we will be discussing some of these. So let me first, I'm sorry, I'm going to be taking my glasses on and off. I can see very well up close, not very well far away. So I'll first begin by introducing our panelists, and then I'll try and just say a couple of words on some motivation that might make you a bit more interested in why this is a very relevant issue to discuss. So first is Mariana, who is a partner at Morais Leitão.
Yeah.
Okay.
That's correct.
And she specializes in complex litigation under the form of mass torts or class actions. Most of her expertise has been focused on commercial contracts, consumer law, product liability, and environmental claims. So thank you very much, Mariana, for being here with us. Hal, who flew a little more than everyone else to be here, is a managing director at Econ 1. He's a career line professor of economics at the University of Utah, and he has worked in federal courts in the US that have certified 15 class and antitrust consumer protection matters. He's also very recently participated in a big case in the UK, the Kent v. Apple litigation, before the Competition Appeals Tribunal, and Dr. Singer testified on behalf of the class, and I won't make you do anything else. And then Jonathon, who's a partner in the London office of Proskauer, and he specializes mostly in international disputes. A good part of his practice concerns competition antitrust disputes, class actions, and group litigation. He participates in multiple jurisdictions and is currently leading the defense of very high-value claims cases before the CAT in the UK. So as our panel stated, if you read through the outline, it is seldom a rubber stamp getting certification. Sometimes it becomes a mini trial in and of itself. And we have a very recent example of this. So in the UK, where certification is a low bar, the case, the UK Kent v. Apple case went all the way, and the CAT recently decided this on the 23rd of October in favor of the claimants. While in the US, a similar case, also very recently, the 27th, only 4 days after the October 23rd decision in the UK, had already certified the class, and the judge decided to decertify the class. So very different outcomes in similar issues under very different circumstances. So with that, I'll start asking questions on this. So my first question is to Jonathon. So could you talk to us a little about how the process looks, how it operates in the UK, how it compares to other jurisdictions?
Happy to. So the approach to certification in the UK, as many of this room I think will already know, is it's still very much a developing and a moving thing. The class action regime is relatively young. There isn't a significant body of case law on the issue, and in part that is because not all of the past 10 years have been particularly active ones. It is, however, said that the UK takes a relatively permissive approach to the issue, and I think the reality is, however, that the amount of evidence that is required at the point of certification can be tremendous, and what we are seeing is that the CAT is generally forensic and rigorous in its approach. So if I had to sum up where I think we stand now in terms of the approach in the UK to certification, it's certainly not a rubber stamp. It can often turn into a mini trial, and I mean, it's typically spoken of as being holding this gatekeeper function. I think I would go further and say that as things stand, its function is a decisive and strategically critical battleground between the parties. And we see that battleground play out in nearly all aspects of the certification process. So to take a couple of examples, in January this year, for the first time, the CAT refused to certify a claim that was brought against Apple and Amazon solely on the grounds that the class representative was unsuitable. And that representative was subject to quite significant scrutiny. She was cross-examined, she was made to give further evidence, she was found not to have a strong understanding of the funding arrangements in place. There were concerns raised regarding her independence and her ability to act in the interests of the class. She was found to be too reliant on the lawyers. So quite a list of criticisms were raised about her. That rigor that we saw there is mirrored in the CAT's approach to what is called the blueprint. So many people in the room, I think, will be familiar with this from the UK perspective. The blueprint is the thing that the claimant is supposed to put forward at the start of the proceedings, which is essentially a methodology on how the case will proceed from certification through to trial and how it will prove the case on a class-wide basis. Now, on the one hand, in the albeit limited case law that we have, the CAT is at pains to say that there can be imperfections in the methodology. It doesn't need to provide all of the answers. The reality is that the level of scrutiny can be quite considerable. Again, as Hal will know, damages methodologies are well tested at that stage. Funding agreements are subject to critique. Class representatives can be effectively sent away to improve the methodology and then come back to the proceedings. But we are now starting to see increasing, I think, examples of this have another go approach being less tolerable. There was a recent case in August, the Roundtree case, where the certification was refused. There was also an application to strike out, so it was somewhat complicated, but the certification was refused because there was no counterfactual put forward, and the class representative was not given the opportunity to go and have another go. You asked about comparisons. I think it depends what you're comparing our regime with, because in some respects there aren't direct comparisons. But if we hone in on a couple for discussion purposes at least, in Canada, generally for most non-competition mass claims, it is considered easier to certify than in the UK. In respect of competition claims in Canada, I think it's relatively comparable. That said, there are differences between the provinces. Quebec, for example, is considered relatively plaintiff-friendly. And arguably, there is less unpredictability in jurisdictions like Canada because they've had a class actions regime in place for some years. Contrast that with Australia. There is no certification process in Australia, no formal one. Instead, the onus is on the defendant to apply to stop the proceedings for a number of reasons, including the various elements to bring the claim of not being satisfied. So put simply, there is quite a bit of variety between jurisdictions, and I think it's often due to different legal traditions and heritage, institutional constraints, and political choices.
Okay, that's very helpful. So what I want to do right now is to pass from the legal to the economic. So how it's been said that the US is very econ-centric. Could you elaborate on that comment also on your experiences here and there, now that you have them both?
Yeah. And I also want to thank GLG. By the way, can you guys hear me okay? So okay, good. I want to thank GLG for inviting me, and it's going to be tough to follow that, but let me see if I can do it. I accepted this speech before I knew how the cat was going to decide the Apple case. So I don't know if I'd be here right now had it gone differently. But I'm going to talk about the U.S. for a bit, and not because I think that U.S. standards are ideal or should be imported, but just to kind of compare and contrast. It is very econ-centric. In fact, I would submit that the entire class certification decision will come down to whether or not the plaintiff's economist's model of impact is rigorous and reliable, is well-grounded in the economic literature, it fits the facts of the case, and if it can show that all or nearly all class members have been injured by the conduct. And just on that last element, the all or almost all, I mean, we spend entire sections of our expert report just trying to prove that. And we've developed econometric and statistical techniques to try to inform whether or not the damages model can demonstrate all or almost all class members. So I don't know if this is going to kill you, but we use this method called in-sample, where we're trying to predict what each class member, say it's a labor case in the UFC. I like to talk about that case too. In which the case, the class was settled and was certified, and the UFC settled for something like $375 million. But in that case, we had to predict for each and every fighter whether his or her wage in the but-for world would have been higher than their wage in the actual world, right? And we had to acknowledge that not everyone in the class could be shown to have suffered injury, right? And there's a certain tolerance as to how many class members can be shown to be uninjured before the class will be certified. I think the only other thing that I wanted to mention quickly here is that we use hot tubs in the U.S., which is a gross word, but it's the word, unfortunately, that we use. But that's where the economists, the dueling economists, are like dropped into a pit. How about that? And to kind of rip each other's faces off. I've done that 3 times in the U.S., and we did that here for day 1 of the Kent v. Apple trial. And what was interesting is that the tribunal asked me to meet with the opposing experts. There were 2 economists on the other side who were opposite me, and both from the U.S., strangely. One was at Penn and one was at Maryland. But we had to meet in person without lawyers, and we had to present a document that was co-authored to the tribunal that showed all, the major issues and areas of agreement and areas of disagreement. But that was something that I thought was actually very helpful, particularly when we did the hot tub, because we could tell the tribunal right away, you know, what we agreed on, what we disagreed with, and it also kind of humanized the experience. We weren't, you know, animals ripping each other's faces off, which is typically the case.
Yeah, no. That joint statement is very useful. I think it's a great document. So let me move on to Mariana. Last but not least, you mentioned that Portugal's system has some concept called benevolence. Mm-hmm. Can you explain it a bit more?
Thank you, Elisa. So the system in Portugal, which has become an important hub for class actions over the past few years, is quite different from the one that Hal and John mentioned too, and in my opinion quite benevolent towards the plaintiff. And why do I say benevolent? On the one hand, because it's quite easy to file a class action in Portugal. You'll pay no initial court fees, and even at the end, if you lose at all, you only pay a minor amount, completely unrelated to the amount you claim. Then you have easy-to-meet legal standing requirements. The definition of the class is up to the plaintiff, and there's no minimum number of class members. You don't need to quantify damages in the statement of claim, and you have an opt-out system. But then, on the other hand, it is also quite easy for the case to proceed to trial, and this is the most relevant for the purpose of this panel, because I think this is mostly related to the fact that we don't have a certification phase, at least in the sense that you have it in the US. So there's no mini-trial where the judge will analyze evidence on the admissibility requirements, no judicial decision defining and certifying the class. So how does it work? So you'll have, after service, 30 to 60 days for the defendant to present its full defense, both on procedural issues and on the merits. In other words, we don't have like this legally required prior decision on admissibility before you go into the merits, which is quite demanding for the defendant. We do have early dismissal decisions in 2 scenarios. So even before service, the court can consider the claim to be manifestly unlikely to proceed, and this entails this very superficial analysis of the merits. And then after both parties submitted the written statements, we have this preliminary hearing, or at least a decision, where the judge will assess if there are any procedural issues that prevent the case from moving forward, lack of jurisdiction, lack of legal standing, and also lack of homogeneity. But still, this decision is based on a rather superficial and procedural analysis of the issue. But to be completely fair, we have seen more and more early dismissal decisions that specifically address the homogeneity issue. And so I won't bother you with the details of Portuguese law, but just to give you 3 ideas that somehow summarize, or I feel that summarize the recent trends. So we don't have a legal precedent, but there's been this common established understanding that homogeneity will exist whenever the same or similar facts or legal issues are at issue, and whenever no different defenses can be argued against one or more of the members of the class. However, this criterion has been applied by court decisions in quite different and sometimes opposite directions. And finally, whenever the analysis of evidence is needed at this stage, the rule is to defer it to trial, which frequently occurs. Now, just to close this first answer, I think the best way to share with you my concerns about a benevolent system is to briefly speak to you about a case I worked on in 2019. So this was a 500 million class action filed against the main steel industry in Portugal for alleged pollution and physical harm to residents and passers-by. So this was the way the plaintiff framed the class. 9 months of trial, 3 sessions per week, over 100 witnesses and 2 epidemiological studies. So at the preliminary decision, there was no hearing for the purpose. The analysis of homogeneity was quite high level. It was understood that the interests of public health and environmental protection was sufficient for these to proceed as a class action, despite the personal nature of physical harm, lung cancer, etc. And at the end, the case was entirely dismissed because no damage was demonstrated, and it was quite clear that there was this personal nature of the claims. So my conclusion of all this is that, or my expectation was that if we had a certification stage, perhaps we could have derailed this before moving to trial. And especially because if this had not proceeded as a class action, it would have been, well, quite impossible for the plaintiff to put it all together, Environmental Protection Association created for the purpose, to ask for this amount of evidence for such a high amount in terms of compensation, and despite having lost it all, only paid a few hundred of euros and all that. So my concern is that this favors abuse of the Portuguese system.
Of course. Well, very interesting case. So we've talked about certification. Now let's move into decertification. As an issue. So even when a class is certified, and the Kent matter in the UK, the Apple case in the US exemplifies this, you can be decertified. So I'll address you, Hal, first, if you have any comments in particular about this.
Well, I do think that there is merit in having a separate hearing over the class certification issue. I think that's fine, because it does present some unique matters. However, there's so much overlap now, at least in the US, between the issues that are debated at class and the issues at merits, that I think that it makes most sense to have a single report, just a single report, class cert and merits that goes in. And I think this makes a lot of sense, because once we talk about the impact model, market definition, market power, there's really nothing different when we get to the merits. It's the same model. So it's kind of silly to have 2 separate reports. And in fact, I feel that when it is 2 separate reports, it gives unfair advantage to the defendants in the sense that the plaintiff can win on class cert and the defense has their own expert, and they have a shot at throwing a whole bunch of crap on the wall, right? And if it doesn't stick, right, you can reset, go to zero, and get a brand new defense expert, and then he or she can just throw a whole new set of shit on the wall, and maybe one of those things will stick. It's almost like double jeopardy. It's like being tried for murder twice. And so I think that just class cert is fine to be by itself, a separate hearing, but just one report is where I think that that's the optimal place to be. As you mentioned, we do see decertification. I've lived through a decertification, but most recently the Apple case where an expert, he wasn't an economist, I believe, I think it was a forensic accountant who was trying to do the allocation of damages, but just allegedly botched it up, and the judge lost faith and reversed her decision. I think there's just one other point that I'd want to make is that even when a class gets certified, in the U.S. at least, there are still opportunities to lose. So I've been involved in 2 cases in which the class was certified, humble brag here, around my impact model, but then the case was lost at summary judgment. Most recent, that happened in INRI bag fee antitrust litigation, and most recently happened in a case involving Invisalign, you know, those teeth straighteners?
Yep.
So Invisalign, I'm trying not to kill you, but the allegation there is that they had been playing nice with third-party scanning companies, right? A dentist could hire one set of companies, one firm to do its scans, and then submit the scans to Align to do the Invisalign aligners. And just after a certain amount of time, Align figured out that they were leaving money on the table, and so they told all the dental customers, we're no longer going to accept scans from third-party scanners. It's got to come from Align scanner. And so a class of dentists sued them. The class was certified, but on summary judgment, the judge determined that Align had offered a legitimate efficiency defense, which is alleged patent infringement. In the judge's mind, that was sufficient to blow up the case. That's under appeal right now, and the DOJ actually weighed in on behalf of the class of dentists. So we'll see what happens in that matter. But I just want to suggest that the mere, again, just giving another example, even though a class is certified, it's not the end of the day. Right? There's still opportunities for the plaintiffs to lose, including decertification.
Of course. So thank you. I don't know, Mariana, if you can talk about decertification in Portugal.
Yeah. As we don't have certification, I'll just adapt it to the Portuguese reality and speak to you about the way to go around early dismissal or preliminary decisions on admissibility requirements. So 2 scenarios can occur. If the judge specifically addresses a certain admissibility requirement and rejects it, for instance, for considering that no lack of homogeneity exists, then this decision will become will have a rejudicata effect, will be binding on the proceeding and can no longer be reverted. And in principle, the defendant will not even be able to appeal from it immediately. It will need to wait until the final appeal to bring it on. But if the court just generally states that procedural requirements are met, then it will be entitled to revert that decision later on. So this would be in brief terms.
And we don't really have have examples of decertification in the UK, but how would you imagine this to happen, Jonathon, if it were the case?
So you're right. I mean, procedurally at least, the possibility exists in the UK. You would file an application and have supporting evidence, or it could be raised of the tribunal's own volition. But you're right. I don't believe there's been any instance so far where the CAT has, or a defendant or the CAT of its own volition has raised the issue of decertification and decertified. But that said, I think it's probably a matter of time. And to pick up, one of Hal's comments about, this not being the end of the day, the double jeopardy, I do sympathize because to some extent, it can, I think, forcefully be said that in some circumstances, claimants are at a disadvantage in the marshalling and the presentation of their case. And they have to jump through a lot of hoops in order to get the case off the ground. And then they have the sword of Damocles almost hanging over them throughout the rest of the proceedings, because if the path does not go in the way they quite predicted, they are liable for criticism for this issue to be raised. That said, it clearly presents tactical advantage and possibility for defendants. And you will often then be thinking about the right time. It's all about timing to raise questions of decertification. You wouldn't want to do it at a stage where the arguments aren't good and you lose credibility. And linked to that, you have to have the evidence to actually back up your application to decertify. And as I say, I think it'll be a matter of time before we see cases on this in the UK, which may well pick up on a range of things. It could be definitions of the class starting to fall apart as the proceedings progress, or the expert evidence being subject to flaws that transpire, or the methodology starting to unravel. What I think is particularly interesting is when we have those cases in the UK on decertification, the extent to which they will inform the process on certification. We're still, as I said, at relative infancy in the UK. There's not a terrific amount of cases out there and guidance for lawyers and practitioners and participants. But you can see how cases in the future on decertification may shift the mind of tribunals on certain issues which they will then have experience of having gone wrong, and that will inform how they approach the question of certification to begin with.
Okay, very interesting. So, mindful of time that we have 15 minutes, I have some other questions to ask you, but if people really want to chime in with questions, I would sort of open the floor to do that. But let me first start with Mariana on the first question, which is, so how do you see things evolving in Europe?
Well, I had this expectation that with the transposition of the RA directive, well, European countries would take the possibility of including a certification phase. It did not occur. Spain is expected to have a certification phase as a result of transposition of the RA directive, but the decree has not been transposed yet. There are in Europe some countries like Italy and the Netherlands with quite robust initial phases. And then again, well, looking at the Portuguese system, although we don't have the certification phase, as I mentioned, we see more care in the admissibility decisions, in the assessment of homogeneity or lack of homogeneity. And we've had this recent decision also in a private enforcement class action on the so-called bank cartel, which, well, a procedural decision to kind of bifurcate the case. This related to the analysis of legal standing requirements. This could be adequate representation, actually, because it related to the conflict of interests with, or potential conflict of interests with funders. Under Portuguese law, this is framed as legal standing. And so the court decided actually to hold a mini trial with production of evidence on that. So although this was a decision related to legal standing, I think this opens the door to a new case management way of handling things, and even to include here the analysis of homogeneity and other issues that could make us closer to certification and mitigate the effects of the system that we now have. Okay, that's great.
And Hal, I feel that we've been rushing you in trying to answer previous questions. And since you've been an expert and you've addressed certification issues, could you talk a little bit more about what you think your role as an expert is to help courts reach a decision on certification? I mean, you've mentioned several things, but perhaps you want to elaborate a bit more.
Okay, sure. So the economist's role, I think the first challenge is to communicate a really complex economic model to a non-economist. That to me is the challenge. It's often a regression model, but not always. And I've had hearings in which one judge, these are separate hearings, but one judge told me this was the first time that he had ever received a regression model before. This was his first. And that scared the crap out of me. And I, on the other end of the spectrum, I had a judge tell me when I was trying to explain the endogeneity problem, which I won't go into, I promise. I don't want anyone to fall asleep. He cut me off in the middle of my answer, and he said, "I know endogeneity. I took this as as an undergrad." And that was the UFC case, and I kind of knew right then that how that was going to wind up. And so I feel that you don't know what you're going up against, but you typically have something really hard to explain. So communication skills, I think, is the first one. I think the second thing that is unnatural for most economists to do is to show some humility, because we think of ourselves as being, I think, special and all that other shit. But I can tell you that in this Apple case, which I'm not going to talk much about, but I do think that these types of cases are the hardest ones that I've ever been presented with, in the sense that we don't have a change in the restraint, right? So the easiest, and easy in quotes here, but the easiest approach that we can do as economists is say, give me a natural experiment. Give me a time where the restraint was either not in place and then it came into existence, and I can tell you what the effect was on prices or wages. Or give me a restraint that kind of grew over time, right? And I could take advantage of that change in the treatment to try to tell you what the effect was on prices. In the Apple case, the restraints that existed in the App Store were the same restraints from day one. So we have no variation in the treatment, which means you have to take regressions off the table. And now we're in the realm of simulations, theoretical models. And I want to tell this to the judge going in, right? Say that this is really hard, and now we're making it even harder given the lack of this. So here's what we can't do, right? I feel like that's important. The last thing, and then I'll shut up, is I think you should also try to show some humor, which most economists lack. Because it gets beaten out of them in the education process. But I do want to relay one last story. I was on the stand for 5 days. The first day, the entire day was a hot tub with the opposing experts, and then days 2 through 5, Tuesday through Friday, was my cross-examination by Apple, and I think that Apple wound it up at around 4:30 or 5 p.m. on Friday. And at 5, the tribunal decided that they wanted to start asking me questions. And I thought it was fun and funny just to ask if anyone had ever been kept on the stand for 5 days in a row. And the judges looked up and down and in the history of the tribunal, and they said, no, I think you're the first. And I said, well, then I think that I should get a little plaque up here on the wall that says Iron Man Singer. And they all started laughing. And I feel like, if you can't inject, humor into the experience, I think you're doing it wrong.
Yeah, no, I agree. I've done the same thing. You need to be a human person before you're an expert. But yeah, completely agree. So, Jonathon, I'll close with you, and please, we can add questions at the end. But what are your final thoughts about the future of certification in the UK?
Lots of plaques, because I think that expert evidence is key to the certification process, as the past 10 years have showed us. And I echo a lot of Hal's comments about the fact that how critical it is to make the complex simple, the long short, and the impenetrable penetrable from the point of being persuasive. And with that said, I think that we will see continued and heightened scrutiny of the certification process. I expect there may be some unpredictability along the way, but I think scrutiny and it will be the kind of the word going forward. And I say that in large part influenced by what is at stake. I mean, the class actions regime and claims that we're seeing have astronomical sums involved. At the beginning of this year, over 160 billion sterling was being claimed through damages before the Competition Appeals Tribunal. So the fruits or potential fruits for claimants are high, and that's not just because of the amounts at stake, but also the potential new ground that may open up. And what I mean by that is, claimants using the competition process in order to air grievances in relation to data privacy issues, the extent to which the competition regime in the UK will allow that. And so that will be the subject of this increased scrutiny. And I think with that goes defendants who will be particularly keen to point out criticisms and errors wherever they may be. Not just, I might add, at the certification stage, but what I think we will see is an increased use of applications to strike out and summary judgments, potentially at the stage of certification, but not necessarily, and a continued monitoring of the basis upon which the claim was certified. Does the class definition still hold muster? Is the methodology subject to new scrutiny, precisely because that opens up the scope to probe certification, potentially seek decertification, and fundamentally question, should this case be allowed to be heard as a class action?
Okay, great. No, very interesting. So I'll open the floor. If not, I'll add a question of mine. But does anyone have any questions that you'd like to pose to the panel?
We were too boring.
So I will pick on one thing that was mentioned, which is this issue of homogeneity. So my understanding, a very long time I worked in the US in class actions at the very beginning of my career, so I was definitely not an expert at the time. So homogeneity is a big issue to decertify classes, whether you really have one class or several classes, whether you can really talk about people being similarly situated or not. Mariana spoke about this a bit when she mentioned that although you don't have a proper class certification process, that can happen. And then from what I've seen in the UK, you have these carriage disputes where it's like there are several class representatives and you decide on who joins them. Could you also use that on how to separate a class into different classes because you think that they're not sufficiently homogeneous? And Hal, if you have anything to add on this based on your experience, and I'll just drop the bomb in the middle of the table and let you guys address the question.
Well, I think if you are a defendant to that type of situation, and with a UK hat on now, you would not be advocating for several representatives. You would be saying that the claim is flawed fundamentally and it should be, for example, struck off. As I say, I think we will see in the near term instances where the definition of the class is subject to challenges in that way. And the challenges may be more nuanced. There are instances in cases at the minute where the class has various subclasses. It may be that the subclasses, in the way that the way the case progresses, reveal fundamental errors in the definitions of the class and the extent to which there is symmetry of position. It may well be open for claimants to seek to address that by having several sets of representatives. But I think if we're talking about cases on foot, I think that makes them highly vulnerable. If we're talking about ways to address this going forward, then that may well be one, and I think we'll benefit from UK case law on this issue when we get it.
Yeah, from Portuguese law perspective, I would say that having different classes, or if I understood correctly, the idea would be to, the case having been brought as one class, and then you find out during the case that you actually have different classes. So my first impression would be that the case should be struck out because the definition of the class is on the plaintiff from the Portuguese system. But seeing how case law has evolved and sometimes trying to, the idea behind class actions in Portugal is that there's this really public nature interest to defend health, consumer protection, etc. So I wouldn't be surprised to have class actions trying to take the most advantage you can take about the way the proceeding was built, but, well, it is not quite clear, so I would advocate to the opposite, of course.
I'll let you have the last word, Hans.
So I'm trying to rack my brain to, if I've been involved in cases in the past in which there were subclasses, but I can think of a subclass being necessary, and maybe this isn't where you wanted to go, but if as a result of a strategy, I'm going to come out of the clouds in a second, that class members, even though they were all harmed from the same conduct, they were harmed in different ways. So let me give you an example. How about a bundling case? I'm just making this up on the seat of my pants, okay? But imagine a hypothetical, ski resort. I don't want to pick on anyone in particular. Just rolled up 20-odd resorts, local resorts, say in the western half of the United States, and then raised the daily lift tickets to say $300 a day as an inducement to coerce skiers to take the bundle, right? And I can imagine that you could have some people injured as a result of that strategy who were the daily. They were the local skiers who had to pay the higher price of the daily, the penalty price, basically of breaking the bundle. And then you have other people who are injured because they bought the bundle at an inflated rate. I could see in that case perhaps having subclasses. It all flows from the same place, but because people are affected differently, they probably would be separated out in different subclasses in that case. How about that?
Okay, yeah, no, I think that's a great example. Please join me, everybody, in thanking our experts today. Thank you very much.